CelebrateOne, a legal aid info session with the Legal Aid Society of Columbus. We have 5 attorneys here from Legal Aid that are going to present on the different programs that they offer, different services that they offer in a variety of specialties, including housing, consumer protection, public benefits, domestic law, taxes, and more. So please feel free to drop any questions you have for them into the comment section. We will have time for a Q&A at the end. And with that, I'm going to turn it over to Tabitha Woodruff with the Legal Aid Society.
Good evening, everyone. This is Tabitha with the Legal Aid Society. I am a staff attorney at Legal Aid on both the domestic and the community economic development team. And I have 4 colleagues here with me, attorneys also who work at the Legal Aid alongside me and be sharing a bit about their work. To start us off, though, I want to let you know Legal Aid is a nonprofit law firm here in Central Ohio. We serve Columbus and neighboring communities, and we provide free civil meaning non-criminal, legal services to low-income residents as well as seniors. So that low-income restriction is on residents generally, but not on the seniors that we serve. 2 things I want to highlight real quick. First is that if you are a CelebrateOne connector, then you will send clients to us by using the legal needs screening tool. You will fill out that screening tool with your client and then email it to the Medical Legal Partnership Team, which is mlp@columbuslegalaid.org. If you are not a CelebrateOne connector or you're not a CelebrateOne participant, then you will just call our general intake line Monday through Friday, or you will go to our website and fill out an application there. The second thing I want to highlight is that we are a staff of about 60 legal workers serving about a half dozen counties here in Central Ohio. In 2019 alone, we served around, I believe it was pretty close to 15,000, I want to say, clients. It was in the thousands. So as you might imagine, we have limited capacity. And what that means is there are going to be 2 different levels of service that we provide. Most of our clients, we give brief advice and counsel. A lot of problems can be fixed just by sitting down with a lawyer, getting on the phone, having the lawyer go over the paperwork, and then providing narrow, strategic legal advice and guidance to the person to let them know what their legal rights are and what their next steps should be. So most of our legal services to our clients are just a few phone conversations and some guidance. In a minority of cases that we do, we're actually going to provide what we call full representation, meaning we might file a lawsuit or we might go to court with the client. So we have a limited capacity in terms of providing that full representation, but many legal problems can be addressed just with that brief advice. So keep that in mind. Just wanted to make that clear up front. In general, that's what our services look like. A lot of times we're just going to be looking over legal paperwork and talking to folks on the phone. And then in some cases, we'll actually be going to court with them or initiating a lawsuit. So with that said, let's go through our lineup here. We'll start with, we'll start with Patsy Thomas. Patsy is a staff attorney here at Legal Aid. She came to us through the Stable Families program and works mostly with the housing team. So Patsy, take it away and let us know more about housing and the Stable Families program. And Jill, actually, you can go ahead and progress the slide forward so people can see the list of different legal specialties that we're able to help with. Yeah, there we go. Go ahead, Patsy. Thanks.
Thank you. As Tabitha just said, I am part of the housing team at the Legal Aid Society, and I'm considered the Stable Families attorney. First, let me just tell you just briefly a little bit about the Stable Families program. Then I'm going to go through some of the housing issues that we cover, and then end up again about with a little bit on the Stable Families program. In the Stable Families program, we assist families that have children that are in school, preschool up to high school, that are in some sort of housing crisis. And we help them with their housing crisis and any other legal issues that they may be going through. they are referred to us by the YMCA through their Stable Families program, or through attorneys in our office, or by other community agencies that feel that we may be able to assist them with their crisis that may be going on. It's any crisis that may affect their current housing situation. So that could be almost anything, whether it is eviction, whether it's going to be paying their utilities, whether they have an issue with their children, whether they are having a domestic issue, anything that could lead to them losing their housing, they can be referred to the Stable Families program. And then we will enter in and help them with that issue, and then make sure that they are stable and continue to be stable from then on. They're in the program for 12 months. But let's go back to the housing issues that we handle at Legal Aid. This is whether you're in the program or not. The housing issues that we handle are evictions, rental conditions and repairs, meaning that, if you need something fixed at your premises, what do? You've called the landlord and the landlord has refused to fix them. You can call the Legal Aid office, and we will tell you what you need to do and what steps to take in order to get the landlord to fix those conditions or repairs that need to be done. You just don't stop paying your rent. They will give you, we will give you instructions on how to go about that so you don't end up getting evicted. Fair housing, making sure that if you are disabled, for example, and you've applied for housing, and you believe that you were denied housing because of your disability, you can call our office and we will look into it for you and assist you in that manner. Security deposits, if you're deciding to move and you know that you're entitled to your security deposit. The landlord refuses to give your security deposit back. You give our office a call. We'll take a look at it and see whether or not we can help you with this and help get your deposit back. And then those individuals that are having issues with your Section 8 voucher, we will assist you in that manner. These are just the broad title of areas that we can assist you with in the housing area. Now, right now, I want to go back to evictions because that is a major issue that is in the headlines right now, and everyone is concerned about it because of, one, the weather. Of course, individuals are being evicted, and also because of the pandemic. So we will get into that in a few minutes, but let me tell you about evictions. We consider it as forcible entry and detainer. FE&D is the legal term of an eviction. Forcible entry and detainer, meaning that, the landlord wants his premises back and he wants to put you out of the premises. Well, first of all, there's two causes of action that must be filed in court. The first cause of action, and I know these are kind of legal terms, first cause of action is the restitution of the premises. That's the actual eviction. That is when the landlord is telling the court, I want that person out of my premises. Period. And they have to give reasons and so forth, but that's the first cause of action. The second cause of action is money damages. Now that gets into how much money is owed to the landlord. They have to prove that also. And those are two separate hearings. If you call our office or show up at eviction court, regarding a eviction notice that you've gotten, we will assist you with the first cause of action, the restitution of the premises, meaning that whether or not you could stay at the premises. Now, I want to go let me go back for a minute. Reasons for eviction. You can be evicted for several reasons. Failure to pay rent. You don't abide by the terms of your lease, or you've engaged in illegal activity on the property. Those are some of the reasons that you can be evicted for. So the landlord has filed an eviction against you, or they tell you, put a 3-day notice on your door saying that if you don't pay your rent, we're going to file an eviction notice against you. Well, all of a sudden you remember, you've heard on the news that there's a moratorium against eviction. What does that mean? It does not mean that a landlord cannot evict you. And that's a misconception that is out there. It does not mean that the landlord cannot evict you. It just means that there are certain things that has to happen in order for the landlord not to evict you. And for you to have that protection, you, the tenant, to have the protection, you must avail yourself to the protections, okay? And that means that there are certain actions you, tenant, must take in order for the landlord not to be able to evict you. First of all, the eviction must be for the non-payment of rent. As I've mentioned before, one of the reasons that you can't be evicted for is non-payment of rent. So for this moratorium to protect you, it has to be for the non-payment of rent. So there's a declaration that you have to sign, you have to file, or fill out and give to the landlord, saying that I am giving you this declaration saying that I want to be protected by the CDC moratorium. In that declaration, there are statements that you are going to have to swear to, saying that, yes, this is correct, okay? And it states that, one, you've used your best efforts to obtain all available government assistance for rent or housing, that you expect to earn no more than $99,000 in 2021, that you are unable to pay rent in full or make full housing payments due to the loss of household income, or the loss of compensable hours of wages, or because of layoffs, or maybe extraordinary medical costs. That you're making your best efforts to make timely payments of your rent. Now, sometimes the landlord may not take it, but you are making your efforts to make payments of your rent if possible, okay? And that if the landlord puts you out, you will become homeless. If the landlord puts you out, you have no place to go. And that you understand that you have to, that this rent is going to become due at the end of the moratorium. And that is something that a lot of the tenants don't understand. They believe that I've given this to the landlord, I get to stay here, and when the moratorium is over, all is well. Well, no, that's not true. At the end of the moratorium, the landlord still can evict you for all of the past due rent. So it's best that you continue to make payments or start looking for someplace else to live. Now, it is a good thing that we do have the moratorium, because it does provide some protection for the tenants. But the tenants, make sure you understand that, one, when you file this declaration, that you're able to prove the issue, the five things I just covered when you go to court, and that you understand that the money will come due at the end of the moratorium. Now, this moratorium has been extended several times, and right now, the end of the current moratorium is March 31st. We expect that as long as the pandemic is still going on, that it will continue to be extended. But again, we don't know. That's up to the the CDC. But we do expect it to continue to be extended as the pandemic continues to exist. The reason it was put in place is that the CDC believes that if individuals are evicted and become homeless, that they're going to, go to shelters, and the spread of the disease, the virus, will continue because, one, they're unable to do the social distancing in a shelter, and they're unable to have the proper protection when they're in a shelter. So it's best that they try to stay at home in their own circle and not go out and live in other areas and catch the virus or spread the virus. So that is the reason that the moratorium exists. Um, Landlords continue to object to courts granting the stay, the moratorium or the stay, because the landlords, want their money. The tenants may rightfully owe them money, but again, the reason for it is because of the pandemic and the spread of the virus. So we do advise our clients that if, one, that they are unable to pay their rent, um, that they file and provide the landlord with a copy of the declaration. But it does not stop evictions from occurring. And again, that's just a misunderstanding of the moratorium. And I believe my 10 minutes might be up at this point. Tabitha, are you keeping tabs on us?
Yeah,
Is my 10 minutes up?
you're at
I
12
think it is.
minutes, but if you wanted to just touch real quick on the Stable Families Program and how wonderful it is,
Thank you very much.
spare
That's
it.
what,
For my
okay.
second.
So thank you. So in a couple of minutes, I'm going to go right back to the Stable Families Program. Once you are accepted into the Stable Families Program, we assist you with problems that are going on in your life. One, nothing can be as stressful as trying to find some place to live while this pandemic is going on. So we will assist you with finding some place to live. We will direct you to other places to live, try to keep you in your current housing if that's what you choose to do, want to stay where you are. We will also, if you're having trouble with getting finances, government assistance, or private assistance from other resources. We'll assist you with that, direct you to resources in the community that can help you pay your utilities, that will help you with down payment. We have even referred several individuals to, and I'll give this plug to CelebrateOne. I've had several women that have been expecting children that I've referred to CelebrateOne to assist them with issues that they needed assistance with during their pregnancy. So we do refer individuals to agencies such as CelebrateOne, whatever that need is, because in the end, all of these other issues that are going on in your life can cause you to have a housing crisis, because you will begin to take that money that you normally use to pay your rent to try to solve that immediate crisis that's going on right then and there. And then when it's time to pay your rent, you may not have the money available to do that. So the Stable Families Program is here to help you from getting into that situation. And that's the end of my presentation, and we'll take questions at the end of everyone else's presentation.
Thank you, Patsy. I appreciate it. Yeah, our housing team does incredible work, and our Stable Families program is fantastic. Next up, we have Jacqueline Gutter. Jackie has been working with legal aid for much longer than I've been here. She is one of the experts we have on staff on a number of different issues. She currently leads our court procedures team and also works on reentry, consumer protection issues, and bankruptcy. So we're going to have Jackie speak for about 10 minutes about her work on those various teams.
Thank you. Yes, hi, my name is Jacqueline Gutter. So consumer, that's my main area of focus, and it's very broad. So I'm going to just kind of touch upon the different areas that we do, and if there's more specific questions, or if there's a lot of time left in for my presentation, I can go into it a little bit more specifically. So within consumer, we do bankruptcy. there are very few cases that we do in-house for bankruptcy cases. We do have a pro bono project as well for where they offer free bankruptcies if you would qualify for our services, but you also have to be 100% or lower of the poverty level. But with bankruptcy, some of the reasons people want to file bankruptcy is if their wages are being garnished. And in Ohio, we have a pretty we have a pretty high garnishment amount for wages, which is 25%. If you're making more than approximately $11,000 a year. After that, then 25% of your income can be garnished for judgments. And for many people, that is just not sustainable financially. There's also no percentage of poverty taken into account. So if you have one kid or you have 5 kids, it doesn't matter. It's just, the same amount. Another reasons for bankruptcies is if your utilities, not water, because water runs with the land, so it's a little bit different. But if your gas or electric is going to be shut off, you can file a bankruptcy and either they don't get shut off or it'll get restored pretty quickly. License suspension. And then sometimes for, evictions and foreclosures, although it won't make it go away, it'll just prolong, it a little bit. And there's generally two types of bankruptcies that we do, Chapter 7 and Chapter 13. We do very few Chapter 13s, but Chapter 13 is a good option if you are behind in your mortgage or if you owe property taxes for your property or condo association fees, things like that, that you can file a Chapter 13 and save the property. If you file a Chapter 7, they will just be able to get out of the bankruptcy stay and then resume. So it's not going to do a ton for you. And we do in-house, we do it's very, very limited Chapter 13s. And so also under the bypass, and this is where I'll kind of go into a little, just quickly, the collectability of individuals. So there's certain types of income that is exempt from most types of collection. And that is, Social Security, supplemental security income is usually exempt because of the amount. It's usually about $750 a month. So that's usually just always exempt. Social Security, disability, and pensions, all of those are exempt for most creditors, but there are some creditors, for example, if you owe federal student loans, your Social Security can be offset. Additionally, let's say you bank with Huntington, you have a credit card with Huntington, and you default on that credit card, and your only source of income is Social Security. There is a common law right to be able to offset what is owed to that bank. So again, if you get exempt funds and you owe money to that bank, you might want to change banks because they can take those exempt funds. Unemployment benefits, veterans benefits, those are all exempt from collections as well. Also, if you have a bank attachment, again, that's if you have a judgment against you and somebody's trying to collect, and they don't go through your wages, but they try to attach it from your bank account. The exemptions are maintained even in the bank account. And what's good is the banks are charged with seeing if you get Social Security or certain types of income direct deposited, then the bank notifies the court that we don't have any money to give. If it is wages that are going in, or it's a gift or some other type of income that is in your account, at least $450 has to be left in the account before they can take any money. So if you have $500 in your account, they can take $50. Also, real property, the first, I think it's up to $132,000 of equity, meaning, that's the amount, if you owe a mortgage, that's gonna impact how much equity is in your home. But at least 132,000 of real property is exempt. With taxes, the child credit tax and the earned income tax is supposed to be exempt. Unfortunately, again, as a consumer attorney, we get a lot of collections cases or people trying to do bank attachments around tax time, because that's when they know people are getting a large amount deposited into their account from tax refunds. And so and the bank does not have to sort of subtract out and look at, oh, well, what was, what part of their return was child tax credit or earned income versus just, regular. So that can be a difficult one, because if you don't raise the exemptions through a hearing, then they're considered waived, which can be a problem. And in that, I'm going to answer at least one question that came in. So aside from bankruptcy, we have something called a bankruptcy bypass program. And that is for people who are long-term uncollectible. So people who, receive permanent disability, maybe you're elderly and receive Social Security or retirement, you don't own any real property, meaning you don't own a home or anything. You can be enrolled in our bankruptcy bypass program. And what that is the it's usually law clerks that are doing it, but supervised by an attorney who will send letters to your creditors, basically stating, this person's income is exempt from collections, they have no assets, and therefore, are uncollectible. Please cease and desist from contacting them. Now, they do have to stop contacting you once they get the letter, but they still could, sue you in court. They can still try to collect through that way, but often they won't, because they know they're not going to get paid, because your income's exempt and it costs money to file a lawsuit. Other areas within consumer that we do, sorry, I'm going to check to see if there's questions. Okay. So this is where I'm just going to kind of brush through everything or real quickly, but for consumer, other calls that we help with is federal student loans, issues with private student loans, state debt collection. So if you owe, if you attend like Ohio State University or go to OSU Hospital or something like that, those are considered debts to the state if you don't pay, and then it gets certified to the Ohio Attorney General's office, and then they can do certain types of collections, like they can keep your state tax refunds and things like that. We do a lot of credit card debt defense. We do medical debt collection defense. We work a lot with car purchases, though that is more of an education piece, because most clients that call in, it's a result of buying a car at like a buy here, pay here. And as soon as they put as is on the contract, that gets rid of any warranty. And we have both express warranties, and that's where you get like a written warranty. But there's also for most goods, there's something called an implied warranty, meaning it's just the item's going to work for its intended use. And through case law, cars specifically, if it says as is, it gets rid of the implied warranties as well, which understandably is a shock to a lot of people, because they'll purchase a car. A week later, the engine could blow, and there's really very little recourse if it says as is. So that's a huge issue. We also defend car repossessions. If after a car is repossessed, a lot of times the lender will sue the car purchaser for the deficiency between what they were able to get at auction and what was still left owed on the contract. We work with Payday Loans. a new statute in Ohio went into effect in April of 2019, which also means that you can't have title loans anymore in Ohio. But unfortunately, for federal banks, there is the National Banking Act that preempts Ohio law. So to get creative, some payday lenders have been partnering with federal banks to get the federal bank to initially give the loan, but they immediately sell it to the payday lender. But there's no interest rate caps on federal bank loans, except for veterans or people. Not veterans. People who are in the military. There is, but. And so that's become a real issue because they're basically skirting state laws by pretending to collaborate with these banks that, again, they're only existing to give the payday loan. So if you do get a payday loan of any kind, you should be very careful about doing any of the online ones, because a lot of those are going to be outside of Ohio and do that. We call it a rent-a-bank scheme. But we've found here, there's also storefronts that it turns out the real lender was the bank, but they immediately sell it. And so you just want to be very careful if you take out a payday loan, because the change in the law here makes the payday loans much more affordable. But again, if they're allowed to get it from these federal banks, there's no interest rate cap, and they're back up to these huge loans. We also do foreclosure defense, and foreclosures come in many ways. There's what most people think of as the mortgage foreclosure. If you fall behind on your mortgage, most loans are federally backed in some way, whether it's an FHA loan, a Fannie Mae loan, a Freddie Mac loan. So most mortgages are federally backed, and that has a moratorium that's been extended through June for any foreclosure. We also will do second mortgage, like home equity, lines of credit, things like that, defense. Property tax is a big one, and there's no moratorium on that. Homeowners association and condo association foreclosures, no moratoriums on that. And then technically a judgment creditor. So let's say you default on a credit card, they file a lawsuit and get a judgment against you, and you own real property, they could try to foreclose. But for a judgment creditor, the $132,000 exemption will apply. So before the judgment creditor can get paid, if you owe the mortgage gets paid. If you owe property taxes, that gets paid. Then you subtract out the $132,000. If there's anything left, then the judgment creditor can get it, but that's very rare. Miscellaneous stuff is, some home flippers, debt settlement companies. We defend against those. There's the Home Solicitation Sales Act, which isn't just about people going door to door. If you contact a company where they don't have a storefront at all, that would fall under a home solicitation, the Home Solicitation Sales Act. And then warranties, people not adhering to or companies not adhering to warranties, stuff like that. So that is my very quick rundown of the bulk of what we see in consumer. And then I'll quickly I am the team leader for the court procedures, which is a fairly new-ish group. And the biggest thing we see on that is there's so if you want to file an affirmative case with court, or in some cases, counterclaims or post-judgment motions have a cost to them, or, appeals, things like that, all have a cost to them. But for access to justice reasons, if you cannot afford it, you fill out what's called an indigency or a poverty affidavit. In the past, there was some subjectivity to whether the judges had to grant it, but a new statute went into effect about a year and a half ago, I believe, kind of taken the subjectivity out of it. So if you're 187% or below the poverty level, the judges have to grant them. But we're seeing a lot of problems with that actually happening correctly. And so that's one big issue. That's probably our biggest issue we're dealing with. Also, though, if you want to seal your criminal record, there's a cost to that, but there's a new statute went into effect capping the cost, because it ran anywhere from, in different counties, it ran from $50 was the lowest up to $450 in some counties. And so that was eliminated and they have a lower cap. And so we also are monitoring that. And then with reentry, they do they assist victims of human trafficking for expunging their criminal records that came about due to their status as a human trafficking victim at the time. Also assist with sealing criminal records and obtaining CQEs, which are Certificate of Qualification for Employment. So for some people who have, a criminal record, and if they're having difficulty obtaining employment as a result of that, they can request from a judge this Certificate of Qualification for Employment to present to the employer. And that oftentimes will assist in their job prospects. So again, that is my very quick rundown. And I'm either, I think my time is up, right, Tabitha? Or did I go over?
You went over a little bit, no big
Sorry.
deal. No, you're
See,
fine.
and I thought that I was going to go under, but so yeah, I can just wait and answer any questions later.
Yeah, sounds great. Thanks, Jackie. Appreciate it. Next up, we have Kathy Hoover. Kathy works with our tax team, which is a wonderful team I enjoy working with. Nearly every attorney in legal aid who's not on the tax team calls the tax team at some point. They are experts on a very difficult area of law. So I'm going to have Kathy speak a little bit about the work that she does, and then also share some information for you that will be important for filing your taxes this year. Kathy, go ahead, take it away.
Hello, I'm Kathy Hoover. I'm a staff attorney here with the Legal Aid Society's Low Income Taxpayer Clinic. So what is a low income taxpayer clinic, which we refer to as an LITC? An LITC assists eligible taxpayers free of charge for tax controversies with the IRS. We are funded in part by grants from the IRS. However, we are not affiliated directly with the IRS or the Ohio Department of Taxation. Everything you share is between you and our staff, and it is completely confidential. So what is a tax controversy? You'll have a tax controversy if you believe the IRS is unfairly taking your tax refund. The IRS is trying to make you pay a debt you believe your current or former spouse should be paying. If you have not filed one or more tax returns and you think you might be in trouble, if the IRS has denied you the right to take a credit or a deduction and you think that the IRS is incorrect, or if you have received some kind of notice from the IRS. And some examples of some notices are a notice of deficiency, a final notice of the intent to levy, a notice of federal tax lien filing, or a notice that begins with, "We cannot allow your claim." There are many, many, many more notices that the IRS sends out on a daily basis, but there's too many to list them all here. We can also help you if you're under examination or audit by the IRS, whether you've already been through that examination, it's been finalized and assessed, and you disagree with the outcome, or you're in the beginning stages of the exam or audit and you need help going through that exam or audit. We also assist with collection alternatives. We can assist with collection alternatives if you file a return with a balance due, or if you are assessed an additional tax after an exam or audit that you are unable to pay. A collection alternative depends on your current financial situation, not your past history, and we can help you assess your collection potential. Some common examples of collection alternatives are one that is called currently not collectible status. If you cannot pay because your expenses are greater than your income, the IRS will put you in a status called currently not collectible, which means they will not actively try to collect from you any of your taxes due, with the exception of taking your state or federal refund. Other than that, there will be no collection action. And then tax debts expire 10 years from the day that they are assessed. So if you stay in currently not collectible until the end of that 10 years, that debt will expire. Another example of a collection alternative is what they call an offer in compromise, where you can settle a tax debt for a lesser amount, and that amount is calculated based on your actual financial situation, the assets and available income that you have. The IRS has a very complex calculation process of how they come up with that number, and it's something we'd be able to help you with if that's the collection alternative that you qualify for. And then there's always an installment agreement. You can either pay your taxes off over 6 years, or sometimes if you cannot afford to pay the full payment, we can arrange with the IRS for you to make a lesser payment until the 10-year collection period has run out. We also help with some state and local tax matters if they relate to the IRS tax controversy, or if there's some other very limited circumstances where we can take a state or local tax case. We do not prepare regular, timely filed tax returns, but we can prepare returns if they are related to a tax controversy. So some other things that we also do, we provide education and outreach for taxpayers and community leaders. We'll actually go out into the community and hold events where we'll educate taxpayers or community leaders on how to deal with issues with the IRS. We also identify some systemic issues that affect multiple taxpayers in low income taxpayers. Sometimes we see issues that affect either several taxpayers or several groups of taxpayers, and we will investigate and involve either the IRS or the state or local taxing authority in those matters to find a way to resolve them to stop those. So who's eligible for our services? It's generally individuals and families who are at or below the 250% federal poverty line, which is a little different from other legal aid cases. And then you have to either be a citizen, a lawful permanent resident, asylee or refugee, or any citizenship status in the United States if you are a victim of domestic violence or human trafficking. So if you're in doubt, just give us a call. If we cannot take your case, we can at least usually offer you some information or some advice to assist you in that matter. As for 2020, the biggest change this year is that if you did not receive one or both of your stimulus payments, you will want to file a 2020 return and claim those stimulus payments as what they call the rebate recovery credit, and it's listed as a credit on your tax return. Also different for 2020 is they're allowing everybody to take up to a $300 charitable contribution deduction, even if you do not itemize your deductions. That is different for 2020. So how about if you need some help filing those tax returns for 2020? We cannot prepare those for you, but you can visit getyourrefund.org. Again, that's getyourrefund.org, and see if you're eligible for free virtual tax preparation services. If you have access to a smartphone or a computer, you can upload your tax documents and fill out some information online, and someone will call you and they will prepare your return virtually and have it filed for you directly. If you don't have access to a smartphone or a computer, you can use a drop-off service. If you call 211, and that's 211, and ask for an appointment for drop-off service, you can get an appointment where you will drop off your tax documents to a secure site. They will then prepare your taxes and you'll come back later to pick those up. You may have to call that number more than once because appointments are taken on a rolling 2-week basis. So if they're full right now, just wait a couple days and call back and see if you can get yourself an appointment. And then if you feel comfortable entering your information by yourself and have access to a computer, you can start at irs.gov and click on File Your Taxes for Free. There will be a list of software vendors for those with incomes of less than $72,000, and you can pick the vendor that works best for your situation. But beware to always start at that irs.gov before you actually start one of those returns. Even if you see a provider listed on the irs.gov free filing website, you cannot go directly later to that website and begin your return because that may not be free. You need to start with the link on the irs.gov and log in from there. There's also some paid tax sites you can go to have your taxes prepared, but be sure to ask for your fees up front before you agree to file with them. And one final bit of advice, if you're having taxes prepared by somebody else, please be aware that you are responsible for everything on your tax return, even when somebody else prepares it. So don't let tax preparers add income, losses, or credits to boost a refund that you're not entitled to, because the IRS will come after you for that information. That is all I have to share. Thank you.
Thanks, Kathy. And I think you've caught us up on time a little bit. So I appreciate you there being so succinct and efficient.
Thank you.
So yeah, if you have questions about taxes, they can be really complicated. We got a great tax team here to help with that. Next up, we have Madison Berry. Maddie is a staff attorney here that works on a lot of different areas of expertise. Maddie works on the domestic team alongside me. She also works on the public benefits team. She's an integral part of the medical legal partnership team. And so what we'll have Maddie speaking about is all the variety of public benefits issues, administrative law issues that we might be able to help you with. And then she'll also recap and go in a little more detail about the referral process for CelebrateOne connectors, how you get your CelebrateOne participants connected to legal aid. So Maddie, go ahead and take it away. Thanks.
Thanks, Tabitha. Good evening, everybody. So today I'll be talking about our public benefits team and what type of cases that we take. So the public benefits team at Legal Aid assists with terminations, reductions, denials, or delays in determinations for SNAP or food assistance, Medicaid and Medicare, prevention retention contingency or PRC, publicly funded childcare or what we refer to as Title 20, and unemployment compensation. So it's important to understand that we don't assist with initial applications for those. You guys will have to apply for that on your own or have a caseworker or something or someone assist you with that. We jump in when you haven't heard anything from Job and Family Services, which can happen, or if you are denied and you believe that you should qualify, or if you have those benefits and you receive notice that your benefits are going to be terminated and you think that's incorrect, we can assist with that. And then if you have benefits and, like for food assistance, you receive notice that your assistance is going to be reduced and you don't really know why and you don't think that's right, we can assist with that as well. We also do some veterans benefit work. We have an attorney on staff who helps with if a veteran has lost their benefits through the VA, and then they also assist with discharge upgrades. We also assist with Social Security benefits. We don't assist with initial applications for those either, only if you have received notice that your benefits are going to be terminated or you have been assessed an overpayment and you think that that is incorrect, we can assist with that. We do some medical debt work. So if you receive papers in the mail saying that you're being sued because of some medical debt with HCAP or some charity care, we can assist you with that. I don't know much about medical debt, so I will have to do research if you guys have questions on the medical debt piece. And then we do some senior work and some kinship care work. So if you know some seniors who are having some issues with nursing homes or future planning, we do some wills and future planning stuff. And then we also do some kinship care. There's some special benefits caregivers can get if they have taken a child in and they're not the biological parents. That's all I have for our benefits team. It's pretty straightforward. And then I want to talk a little bit about the MLP piece. CelebrateOne is part of our medical legal partnership. And because of that, there's a special referral service. We have a special screener for CelebrateOne patients. And once they complete that screener, they can send it to the email on the slide, mlp@columbuslegalaid.org. There's also a fax number on that screener. You can send it via fax if that works better for the connector. On that screener, it's basically just asking really simple questions to determine whether there is a legal issue. So like, are you having issues with housing? Have your benefits been terminated? Is there domestic violence in the home? Just like very simple, straightforward questions, yes or no. And if at the end you determine that there is a legal need, you can send it on over to us. We should be in contact with that person within 72 hours, 3 days. If you haven't heard back from, or if the patient hasn't heard back in about 3 days, please reach out to us and let us know, because we want to get connected with those patients and we want to do it quickly. I don't think we're working on new screeners. They're not ready yet. But I don't think there's a spot on the screener that asks for an email from the caseworker or the connector. If you are a connector and you feel comfortable putting your name and email on that screener, that would be very helpful for us, because if we are having issues getting in contact with the patient, maybe their phone has been shut off, maybe they moved. There's a lot of reasons why we might not be able to get into contact with them. If we can get into contact with you and let you know that we are trying to reach out to them and we're having issues, we can brainstorm ways to get connected with them, because at the end of the day, we do want to get connected with them and we want to assist them if we can. And I think that's all I have, Tabitha.
All right, wonderful. Thank you, Maddie. And then I will cover the last little bit. I will try and get through this portion by about 5:55, so we have plenty of time for questions and to chat with you, just in case you have any specific questions about legal information that you would like. And actually, if you could progress the PowerPoint slide, the next slide there lists really just links to our website. So if you go to www.columbuslegalaid.org, you will see under the section Get Help, there are lots of different areas of law that we specialize in. And under those different tabs, you're going to find instructional videos, attorneys talking you through filling out court forms. You're going to find frequently asked questions, and then also actual links to different IRS forms, court forms, all different types of forms that you might need based on your legal issues. So I'm going to talk about 4 areas of law that we practice in. I practice in domestic law, and I work on our community economic development team. The other 2 areas of law I want to highlight is immigration and education. So first, with domestic law, we provide legal services to folks regarding divorces, custody cases, child support issues, and civil protection orders. So within those areas of law, there are certain folks that we're going to prioritize when it comes to things like full representation. So if you're a CelebrateOne client being referred through the MLP, then we're going to do our best to at least connect you to a lawyer who can talk with you on the phone and review your legal paperwork and give you a general idea of where you should go with your divorce case, your custody case, child support issue, or your civil protection order. For folks who, for example, have a situation that involves domestic violence, that involves child abuse, that involves barriers to access to justice. So situations where clients may have be differently abled neurologically, may have a physical disability or a mental health disability, where clients have a language barrier or a cultural barrier that makes it difficult for them to advocate on their own. Those are the kinds of cases that we need to prioritize for full representation in court. So generally, most of our caseload currently involves domestic violence and child abuse. Most often it's both. Our domestic intake tends to be pretty packed. Some basic legal information that might be helpful for your clients. In Ohio, if a mother is unmarried, then upon birth, she automatically has full legal custody of her child. What does that mean? That means that even if someone's name is listed on the birth certificate, as long as she is unmarried, she is the one who has full legal right to determine who that child visits with, when they visit with them, what happens with them medically, medical decision-making, educational decision-making. A single unmarried mother, upon birth of that child, has full legal custody. The father of the child does not have rights to visitation or a duty to pay child support until either the mother files a child support case or the father files a custody case. Now, here's something that's important to know. Once a father files a custody complaint, the court is inclined to give him joint legal custody, which means that he would have the same legal rights as the mother. A right to medical decisions, a right to make educational decisions, a right to have the child unsupervised overnight in his home. So if a mother does not want to have joint legal custody with the father, doesn't think shared parenting is in the child's best interest, then there needs to be evidence presented to the court about why. So that is That's different than other countries. That's different than the law was in the past. And so a lot of people are surprised to hear that fathers are given equal weight as mothers in the court. Now, if a mother is married, then whoever she is married to is presumed to be a joint legal custodian. So a woman's husband will have a duty to support the child financially, will be given authority to make medical and legal decisions. And so this is why it's important so for example, if you are married and you have separated from your husband, and maybe you are now in a new relationship and you're hoping to have children together, it's important to get that divorce filed because they will put your husband's name on the birth certificate automatically. So that's just kind of an interesting legal thing to keep in mind. Currently, same-sex spouses do have joint legal rights to children between them. It's a newer thing for the courts since we did not have marriage equality until just a few years ago, but now we do have marriage equality. So we are seeing cases where I actually had a case where a woman's wife did have joint custody of her children that she had during the course of their marriage. And so the law is not solid on that yet, but they're currently working it out in the courts. So those are just some interesting divorce, custody, legal issues to keep in mind. When it comes to civil protection orders, it can be difficult to get a protection order unless there has already been situations involving physical violence. Under the statute, it says specifically that if there are threats of physical harm, that should be sufficient to get you a civil protection order. So what you want to bring to court for a civil protection order is proof of your physical injury, or if there has not been a physical attack, then proof that the other person threatened to physically harm you or made you believe that you would be physically harmed. So what the statute says versus what actually goes down in court can be different. Most of the time, it can be a challenge to get a protection order unless physical violence has already occurred. But the statute is written to advise the court, you need to give protection orders to people to prevent domestic violence from happening. So that's the tricky thing is what we see our courts actually do versus what the actual law is about when you have a right to a protection order. So those are just some basic things to think about there. So pivoting to my community economic development work, I really enjoy this work in particular. So under the Neighborhood Stabilization Grant, we are focusing on 4 neighborhoods: Hilltop, Linden, Near East Side, and South Side. Focusing on economic development in those neighborhoods. What does that mean? That means that overall, we're trying to reduce poverty levels in those neighborhoods by promoting economic activity, promoting jobs, promoting businesses, promoting income. So what we're currently doing is I am working with Paul Bryson, another attorney on staff, to provide free legal services to small businesses and nonprofits that either are located in those neighborhoods or whose work impact those neighborhoods. So what does that mean? So in terms of business law, we are reviewing commercial leases. We're helping folks incorporate their businesses, helping them decide if it should be incorporated as a C Corp or as an LLC, the most strategic incorporation. With nonprofits, we're helping them get tax exemption through the IRS, get 501c3 status. So how does that apply to CelebrateOne participants? Well, if you have a client who is maybe doing kind of freelance work, maybe she is cleaning houses and getting paid in cash, it might be worth incorporating an LLC so that she can silo the income from that particular activity from other sources of income. So if you, unlike our domestic intake, our community economic development intake is wide open. So we are actively searching for more business clients, more nonprofit clients. So if you have anyone who might have a need for business or nonprofit services, send them on over to mlp@columbuslegalaid.org and we'll see what we can do for them. The other 2 areas I want to highlight is immigration and education. We just recently hired an immigration attorney. Stephanie has actually been working with our program for a while, but we just transitioned her over to doing immigration law full-time. Now, because of her funding, she is limited. Our funding is coming through a partnership with the Our Lady of Guadalupe Center. That is an organization here in town that serves the Latinx community. They do fantastic work. And so right now she is limited to just taking referrals through the Guadalupe Center for Immigration Law Services and specifically focusing on the Latinx community. We hope that in the future we will expand our immigration team and expand our immigration work. But for now, immigration services are only being provided to those limited clients coming in through the Guadalupe Center and who are from the Latinx community. So just a heads up there. Our education team is led by Demi Johnson, who is all around incredible attorney, and she is focusing on a few different areas. So in particular, we see high rates of discipline among children of color and among children who have disabilities. So often what you see is children of color are perceived unfairly as being more aggressive than other children. And so whereas other children white children may be presumed to have a learning disability and just need a little extra help when they're lashing out in class, children of color are disproportionately disciplined, given detention, or even expelled, when maybe the reason they're lashing out is because they're not being educated the way they need to be. And so Demi and her team. She's now gotten a lot of other staff attorneys involved in our education work. Our education team now works to go into schools, make sure that children have individualized education plans, IEPs when they need them, 504 plans when they have a right to them, and making sure that they're not unfairly disciplined, given detention, or expelled when they have a right to be in school. So our education team, that's just one chunk of what they're focusing on right now. They've also been doing a great job on social media. So check out our Facebook page. They've been putting tips for parents and for kids on their educational rights on a regular basis. So you'll be seeing a series of those. So those are all the different areas of law that we work in. And it seems like a lot of different areas, but yeah, just know generally it's civil legal services, so we're not able to provide representation on criminal cases. But yeah, all those other areas of law, we are able to assist folks. If you're coming through CelebrateOne, you can go through that special referral process. If you're not, you can call our general intake line at 614-241-2001. Monday through Friday, and an intake person can process you that way. But if you're with CelebrateOne, you're going to want to come through the MLP. So that said, that is everything we wanted to cover. It's 6:01. Looks like we have one question coming through, and the other attorneys on staff, Maddie, Kathy, Jackie, Patsy, if you want to chime in on this, please feel free to. The question is, what are some common misconceptions about what legal aid can and can't do? So I can start there. Something I do see a lot is folks will reach out asking if we can represent them in criminal cases, and we can't do that, which is frustrating. But what we can do is help people with sealing, as Jackie mentioned. We can help people with sealing their criminal records once their cases are wrapped up. Something else that I see a lot is people may reach out about personal injury cases. So people may reach out about fender benders, car accidents, medical malpractice, and personal injury is generally not an area where we practice. A lot of times personal injury lawyers will take your case for free up front with an agreement that you'll pay them if they can get a settlement for you. And so they actually get paid out of the settlement essentially. And so there's not as much of a need for our services there. Something else is we do custody cases, but only private custody cases. So custody cases between relatives or parents. So where it's a mom versus the other mom, or a dad versus a mom, or a grandma or grandpa versus another parent, aunt and uncles. But if children's services is involved, you have a right to a court-appointed attorney that's paid for by the government. So we do not do custody cases that involve children's services or that are initiated by children's services. Anybody else want to chime in on some misconceptions we see around what we can and can't do? Anybody else? No?
Well,
Go ahead, Jack.
this is Jackie. I'll just say we don't really do, there's some very limited, but we don't do much probate. And then as Tabitha stated in the beginning, you know, because the need is so far outweighs the resources, we do a lot of counsel and advice. And so I think just generally, you know, we will get questions about what do we do if we can't help people. But unfortunately, that's a lot of times the best way we can help people. And then again, as Tabitha also said, was we don't do criminal, and I think maybe it's the law and order where legal aid in New York is the public defender's office, but we get you know, calls about that.
If I may say something, Tabitha, and that is that more than likely we cannot represent you when your court date is set the day after you call our office. And I'm saying that to tell individuals to make sure you give our attorneys enough time to look into your matter and make a determination as to, one, if it is a issue we can represent you on, and to prepare to meet you at court and be able to provide adequate legal services. The only time you'll get instant service is in an eviction. When you come to court, we do have our TAP team that is providing services to tenants that are being evicted or have an eviction hearing that day. You can come and go to our counter that we have set, or a table that is set up, and there's only so many tenants that we can see a day. You'll sign up and determine whether you are eligible to be served by a legal aid attorney. And once that's determined, one will be assigned to you and will represent you that day because you have a hearing on that day. But that is the only time I know where a legal aid attorney can assist you at a court hearing immediately. Otherwise, please, please, please give enough time so that our attorneys can make a proper determination and provide adequate legal services to you.
Yeah, thanks, Patsy. There was a follow-up to that question too, which was if we do encounter people who need help with a criminal case or personal injury, can we refer them somewhere? And absolutely we can. So the Franklin County Public Defender's Office, and Jackie made a great note of this, is way back when legal aid first began, we did both criminal and civil. At some point, the criminal chunk broke off, and that's when public defenders became a thing. So the public defender's office and the legal aid office were once one and the same, and now we operate separately. So the public defender's office is now part of our local government, part of, well, depending on which courthouse, they're kind of integrated into the courthouse itself. Whereas legal aid is now an independent 501c3 nonprofit. But yeah, we definitely, when we can, we will refer people to the public defender's office for criminal issues. And then I know a couple personal injury lawyers in town who I think do a really good job. And so when I come across those cases, we do what we can to refer folks to people that we know and trust. So good question. One other question.
I just wanted to add. Sorry, I just want to add to that we also the Columbus Bar Association has a pretty good referral site. You can put in what area of law you need. If you can do it online. If not, I provide the phone number too in my letters where you can just contact the attorney referral line and just state what area you need. The other thing is, and this is because I'm consumer, so it's kind of specific with consumer, but the Ohio Attorney General's office, sometimes we will refer to them as well for certain consumer issues.
Yeah, thanks, Jackie. And looks like there is a new question. This one I'm going to be kicking to Patsy, so get geared up here. Can you explain the difference between giving 3-day, when a landlord gives 3-day notice versus a landlord filing an eviction?
Yes, I can. By law, when a landlord determines that they want a person out of their premises, they must first give a notice. Now, if it's a private landlord, meaning that the landlord owns the property and it's not being subsidized by the government, they must give the tenant what's considered a 3-day notice, saying that I want you to leave these premises by in 3 days, and the reason is because you have failed to pay your rent or non-payment of rent. And I am summarizing what this notice has to say, but by law there is specific language. It has to be printed or stated in a specific manner, has to be bolded, has to be in large print, cannot be tiny and hidden on the notice. It has to be standing out so that you know that the landlord wants you to move, and it's considered, the 3-day notice. That's before they file anything in court. So you get this notice. It's usually posted on your door, telling you that you have to move. So that's your service of the 3-day notice. After that, okay, they can file in court an eviction, okay? After 3 days, they can go to court and they can file an eviction. Now, they don't have to file the eviction. You may get with the landlord and resolve this. Or the landlord may just take their time and file something in court. But the first thing is the filing, the posting of the 3-day notice. Then the landlord has to go and file the eviction in court. Now, the eviction, the filing in court, consists of the summons and a complaint. Okay, so they type up a complaint that says, number one, they're the owner of the property, their address. Number two, that there is a lease and that you violated the lease. Number three, you were supposed to pay your rent per the lease by the first of each month, and the rent was so much each month. Number four, you failed to do it. Number five, they want you out of the property. Maybe a number six, but that's basically what the complaint is going to say. Okay, and then they have to have a summons where they're asking the court to issue a summons for you to come to a hearing to be evicted out of the property. This summons and complaint must be served upon the tenant in a specific manner. Okay, and it has to be done, usually it's done by certified mail, because when they send it by certified mail, then the return receipt, what we call the green card, the return receipt comes back to the court, telling the court that, yes, you were served. That has to be done. You must be served. And then when you get to court, we look to see, one, were they served? If you were served, then we look to see, two, did they post the 3-day notice? Does the 3-day notice, is it prepared in the proper way? Does it have the statement notifying you that the landlord intends to have you evicted? And then we look to see, was the complaint filed in court with the lease attached, stating that you violated the complaint by not paying your rent. So those are the two things that must happen in order for the eviction process to start. Normally, individuals think of those two things as one thing, and they call all of that the eviction process. So they think of all of that as one process, but it's not. It's actually two separate events that must occur.
Okay, so the 3-day on the 3-day notice is referring to the landlord has to wait 3 days to file that eviction after the notice, right?
Yes, yes, but they
Okay.
could take longer.
Yeah, they could
They-
wait weeks, days. Yeah, I think a lot of people get a 3-day notice and they think that means they got to move in 3 days. I think
No.
that's a misconception people have.
Correct, correct. The landlord does not have to file immediately after they give you the 3-day notice. They do not have to go down to the court on the 3rd day or 4th day and file their complaint. No, they're just giving you notice that they intend to have
Right,
you.
if they intend to file an eviction in 3
Yes,
days or maybe not at all, right?
correct.
And a landlord, can a landlord boot you out without filing an eviction, without that court order?
No, no. A landlord cannot put anyone out of their premises without a court order, without a court order saying that yes, you can um, regain your premises. Um, they cannot do self-help and lock you out of the premises. There has to be a court determination, a court order saying yes, this individual must leave the premises. And even then, they can't. They still have to follow certain rules in order to have you leave the premises. If you don't, if you don't leave, even after the court has told you to, the landlord can have a writ, meaning that they have to go back to court, file additional money saying, I want the sheriff to come and set these individuals out. Okay, so meaning that the sheriff now comes to the property and will allow the landlord to go in and move all of your belongings out of the premises. But the sheriff will stay there until that is done. The landlord cannot just go after they've gotten an order from the court saying you're entitled to evict the tenants. The landlord cannot just go in and do it. They must go back to the court and pay for a writ of restitution and go and have a sheriff come and sit there while they move the tenants' belongings out of out of the premises.
Yeah, thanks, Patsy. That's super important because I know I've certainly had clients where they got a 3-day notice and then 3 days later the landlord showed up to throw out their stuff and said, no, 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 you talk to Patsy and the team. They are not allowed to do that. They have to wait 3 days to even file the eviction and then through the eviction get a court order and then after that get the writ or else they can't touch any of your belongings.
They
So
cannot.
very, very important. Thank you. Great questions that we got there. Well, if we don't have any other questions, we can probably wrap up. Jill, do you have anything else for us?
I just want to say thank you so much. This has been such great information, and I really appreciate you guys doing this presentation. And if anybody wants some more information about legal aid, their website is columbuslegalaid.org, and you're also welcome to message CelebrateOne if you need help for pregnant or parenting families, or if you want us to connect you with the team here at Legal Aid. So thank you very much.
Thank you, Jill. And thanks everybody on the team. Good to see you. Everyone have a great night.
Thank
Thank
you.
you. You too.